I apologize. I'm not optimistic today. People who know me know that I'm a very optimistic and proactive person. I tend to see solutions before I see problems, but not today. I have to be honest. This is a little bit my impression when I was called by Jean-Pierre to come and speak with you. I don't have any good news so far to share with you during the few minutes I have. It's important that I tell you that because I'm very impressed by the two presentations I just heard and the one that I was able to have access to, in the sense that you are working for solutions, but you are working in a context that is much broader than yourself, and this is something you have to take into account, because the situation right now is not so much fun. You know the complexity of the ethical and legal and social issues linked to personalized medicine and what you are doing. I only highlighted in red here elements that are more connected to data protection. If I take other sources, I can highlight other questions. I'm not going to elaborate on them, but we have to be aware that there is a problem. And I want to give you one small case study. I don't know if you heard about the case of Zintra Eberte. All right, Zintra, she was born in Latvia. She was married, and her husband died from an accident. Her husband's body was brought to the forensic center of Riga for an autopsy. Well, a year after, 2 years after, she learned by the police that the Riga Forensic Center was under action for stealing body parts and body parts trafficking. The case went to the European Court of Justice because this activity was known by the Minister of Health, it was agreed by a Research Ethics Committee, everything seems to be fine, except the fact that the consent of Zintra Eberte and her husband was never asked. At the end, the Court of Human Rights in Strasbourg granted her 16,000 euros as damages, which is a huge amount for the European Court of Human Rights. Usually you get nothing except the fact that you have won. And they say thank you. Here, the amount is really very important. It's like almost yearly revenue for Latvia. So it's a huge amount. And the condemnation was against violation of Article 3 of the Convention, which condemns the fact that the person was humiliated in an individual way, showing a lack of respect for human dignity. So it was very severe. But why do I tell you all this? Is that the researcher working for the forensic centers in Riga said, oh, we were following the law. We follow the rules from our boss. The boss told us we could do it. It was not a valid excuse for the courts. Why do I give you this case? Because I've studied other cases, and the courts are not friendly to researchers dealing with human biological material and data. They are not friendly. I saw that there are a lot of companies trying to sell out what they are doing and say, oh, it's fine, it's funny, and enjoy it. Well, when there will be a case, they lose, at least in Europe. So there are challenges today in personalized health research, growing complexity of the normative framework, limited specificity of the normative framework, which means that you don't really know what you have to do and how to cope with it, and you may also lack training concerning the ethical and legal issue. Now, how many of you have heard about the Declaration of Taipei? Raise your hand. All right. How many of you have read it? Good. How many of you have a quality assurance system making sure that your institution is working in accordance to the Declaration of Taipei? All right, we have a problem. The fact is here, it's only a limited number of the regulation applying to your work. Okay, it's a limited number. There is another page on. Okay, just to show you the complexity of the situation today. So if I take the Declaration of Taipei particularity, adopted in 2016, and there is exactly the same text, very similar text adopted by the Council of Europe. For the first time in the history of research, regulation, research ethics, the stress is not done about balancing interest and so on, but about governance. How do you cope with your data, with your material? You need to respect some fundamental principles: protection of individuals, transparency, participation, inclusion, accountability. How do you do that? You see, you have 13 items listed where you have to take actions to make sure that what you are doing is correct. Now, I'm impressed by the cryptograph that you are, the work you're doing. You're actually trying concretely to find solutions. And this is very important. But if the solution you are trying to build are built on material that have been collected unlawfully, you're building your system on a very fragile ground. And this is a concern. Because you have to connect the consent form and the declaration of type A requirement on governance. Actually, in Switzerland and in other countries, all the stress is on informed consent. And I just went on the website of the Global Alliance, fantastic website, a lot of information. How do you actually verify that the consent was obtained properly and that it is valid? And that when you say we are protecting your privacy, when you say we are making sure that we will follow your will in the way we are going to use your data, how do you guarantee that to the people you are saying this? Well, you cannot do it if you don't have the governance in place. And this is very important. In Switzerland, you have to be aware there is a general consent form from the Swiss Academy that has been contested by all the major patient organizations. None of the university hospitals are using it. There are several ethics committees that have already mentioned that they don't find this form valid. And you also have data protection authority. I have at least 2 of them that have confirmed that this document is contrary to the data protection regulation in Switzerland. So if you're dealing with the data that have been collected based on this consent, you may consider that you are doing something that is not. There are other issues that you have to be aware of. I don't know if you know the right of portability. Many of you are aware of it, but no, you get it in the general data protection regulation in the EU, and it's getting enforced in May 2018. Now, fantastic scripting, you do your cryptography and so on, but how do you guarantee that I come to you and I say, look, Jean-Pierre, I like my data, and I like my data here. Oh, I cannot give I take yours. I want my data on this USB key. This is portability. Can you do that? Can you do it? You have to be able to do it in May. And I know that in Europe they are struggling with this, but you have to integrate these elements. This is why I tell you, I feel that the sky is a little bit stormy right now, especially there is another element that I want to inform you about. That was 2 weeks ago at the Federal Parliament, discussion on the revision of the Genetic Analysis Federal Act. The private insurance convinced the Commission at the Conseil National to eliminate the restriction to have access to genetic testing. So it means that insurance, if this passes, and I hope that you will resist, I hope the Academy and the researcher community are going to react very quickly, because it means that any insurance will ask anyone, have you passed a genetic test? And if the answer is yes, we say, okay, we want to have the results. It means that I will advise, as a lawyer, I will advise anyone not to do any genetic test unless it's absolutely necessary. It means your research is over. Because you want to have access to data, and the people are saying, no, I'm not going to let you do what you want to do, because if you do that at one point, and then I have the portability that will allow me to get my data back, and the insurance are going to use it. It's a catastrophe. So it feels very stormy right now. So there are solutions, and there is a solution, and I really think it's important. The lack of specified regulation doesn't mean that you are free to do what you want. It means that you apply the general rules of law. And actually, the general rules of law in Switzerland are not so friendly for research, in the sense that you absolutely need to have informed consent to use the data. The trend today in data protection is to be more restrictive. So most of you Many of you may be working in public hospitals, and the cantonal data protection authority are more and more saying, well, we want to have a legal provision to allow you, above the consent, to treat those data. So it's going to be more and more difficult unless we have a specific regulation. There has been a proposal, motion Rebecca Ruiz, to have a federal act on biobanks that will also be expanded to personalized health. I heard scientists saying, oh no, we don't want to do, it's too complicated, it's not going to help us. Well, you're completely wrong if it's what you're doing. Because if you don't have a specific law, you will have the general rules. And the general rules are the General Data Protection Regulation, or the Data Protection Law, or the Civil Code, or the Constitution, and those texts are not researcher-friendly. They are not. And that's why I wanted to raise to you the case of Elberte versus Lavia, which is 2015. And I find it important to change the situation. I want to be optimistic. Where is the solution? Maybe you recognize yourself. I'm sorry, I did not ask your consent. I will erase this picture. That's why you are in the front, but it's important because you are the solution. SBP, Swiss Biobanking Platform, SPHL, I don't know. You have to clean up a little bit the situation, adopt clear governance system. Refrain yourself in collecting data today. I will really ask you, think twice what you are doing. It's fantastic if you develop all this cryptography and all these solutions that I really find amazing and reassured. I love what you said. You say we have to be ready to move from a situation where we have unlimited access to the data to a situation where we have to accept that we will have more difficulties, but we will have to secure those data. Because for the moment, a lot of scientists believe the data belong to me, the biological material belongs to me. This is just wrong, legally wrong. So you have the solution, you are the solution, and I wish you good luck.